Good afternoon, everyone, and welcome to the final instalment of our COVID-19 series of webinars this month. Today, we're actually taking a bit of a break from coronavirus, and we're going to have a think about some of the other key people issues that HR practitioners should have on their radars for the rest of this year. For those of you who don't know me, I'm Ed Mills, the head of our Employment and Business Immigration team here at Travers Smith. And with me is Moji Oyederan, one of our senior lawyers who specialises in business immigration. And we're also going to be joined by Adam Rice, one of our Knowledge Counsel, who many of you will know as well. Now, today's webinar has been pre-recorded, but the good news is we've had a chance to look at some of the questions that you've sent in over the last 24 hours, and there is still the facility for you to submit questions today as the session runs via the chat box, and we can pick up with you afterwards. So in terms of what we're going to cover, well, perhaps the number one issue on the HR agenda, aside from COVID-related issues, is Brexit. It was all anyone was talking about this time last year, but with the current pandemic, it's quickly slipped onto the back burner. So in a moment, I'll hand over to Moji, who's going to take us through the key immigration implications and what employers need to do now to prepare. I wanted to pick up another hot topic, which may have slipped onto the back burner as well, but is going to take on great importance in the current climate, and that's whistleblowing. So what should you be doing as an employer to encourage best practice, and how can you go about encouraging a speak up culture where staff are comfortable raising issues, aside from changing the name of your policy from a whistleblowing procedure to the perhaps more empowering speak up policy? More on that anon. As I said, this has been a hot issue in recent times, and it's only going to get hotter as people come back to work and start to raise health and safety concerns. Then I'll hand over to Adam, who will be taking us through some considerations on employee mental health and well-being, another huge challenge for businesses at the moment, as well as the April 2020 changes to employment contracts. And finally, we'll finish up with the delay to the off-payroll rules and what that means for you. So a lot to cover today. As I said, do submit your questions via the chat box, and we can pick those up with you separately after the session. So without further ado, Moji is going to kick us off with Brexit and immigration.
Thanks, Ed. So we're currently in the Brexit transition period, which will run right through until the end of the year. So that means very little has actually changed from a practical perspective in the aftermath of Brexit Day at the end of January. Now, EU nationals continue to enjoy free movement rights and can still come to work in the UK without any visa formalities. All that is set to change once the transition period ends on the 31st of December. Now, there are two key standpoints to consider here. Firstly, the implications for existing employees, EU national employees, and also secondly, the implications for any new hires you bring on board. So turning first to look at the existing employees, well, EU nationals who are already here, or anyone who actually moves across before the end of this year, will be able to apply for status under the EU settlement scheme. And they will have until the 30th of June 2021 to apply. Those with less than 5 years of residence will be granted pre-settled status, and anyone who has acquired 5 years of qualifying residence will actually be granted settled status to live in the UK indefinitely. So what about new hires then? Well, under the new points-based system, they will become subject to the same rules as non-EU nationals coming to the UK. Now, the new system will be introduced from January 2021, and it will mean that EU nationals will need employer-sponsored work visas to be able to work here. Now, as some of you will know, work visas for non-EU nationals are currently covered by the Tier 2 regime. That regime requires employers to sign up to certain compliance obligations in order to be granted a sponsor license. and the UK Visas and Immigration, the UKVI, are then able to conduct spot checks on how they are complying with the requirements. The new points-based immigration system will build on the current Tier 2 regime, but there will be some changes to streamline it. Now, one of the key helpful changes is the removal of the resident labour market test, which will mean that employers will no longer have to advertise a role to show that there are no suitable settled applicants when looking to recruit a non-British national. Also, the new points-based system will cover a wider pool of jobs than we have under the current regime, as it will also include jobs that are skilled to A-level standards, so expanding from the current graduate level, that is the skill level requirement. The minimum salary threshold will also be reduced. It will go down to 25,600, or whatever the specified going rate for the job is, if that is higher. Now, individuals will need to score at least 70 points to qualify under the new points-based system, and those points will be based on specific characteristics, including holding a job offer for a job which meets the minimum skill level, and that needs to be from an approved sponsor, so an employer that has a sponsor license. They'll also need to meet the English language requirements and must be paid at or above the minimum salary level for the role. Based on current statistics, it's interesting to note that actually most employers are not yet registered sponsors. There are only around 31,000 odd businesses that are registered on the UKVI's register at the moment. So we are expecting a significant number to need to apply under the new regime. At the moment, it takes around 8 weeks on average to process a sponsor license application, the UKVI say, but no doubt the increased volumes will have a knock-on effect on these processing times. So applying sooner than later for a license, if you think you'll need one, is a good idea. Now, a key part of the application process will be the need to show that you have good HR systems and onboarding processes in place for compliance. Compliance is a key element of the sponsorship regime. And it includes things like monitoring, tracking, and reporting obligations that you will have as a sponsor employer. Also, the application process involves you submitting certain key documents to the UKVI to show that you're properly established in the UK. Now, it's a good idea to start to look at these elements in good time and seek help if you need it. We've already started to see an uptick in new instructions for sponsor license applications ahead of the introduction of the new immigration system. So not companies who are looking to sponsor anyone at the moment, but where they're getting themselves set for the new system. Now, one other aspect that I think it's worth just touching on, just to finish off, is that for UK nationals who are travelling to the EU on business after the transition period ends, they will face new entry requirements. So remember, they will no longer be entering as EU nationals. So in effect, they will be subject to the same entry requirements as any other non-EU national who is travelling to the EU. In practical terms, that means they will need to be ready at the border to confirm the purpose of their trip, of their visit, and also the duration of their visit on arrival. They'll need to hold a current passport with at least 6 months validity remaining. So that all sounds very different from the current position where you just pitch up with your red EU passport. So they'll also need to be mindful of the limits on the number of days you can spend in the EU as a non-EU national. Post the transition period, you will be subject to similar limits that apply to non-EU nationals currently. So as a business, you should look to update your business travel policies and send out comms to individuals who do travel on your behalf in the EU, so that they are aware of the new requirements in good time to prepare. That's
Thank
all I'll
you
say.
very much for that excellent summary, Moji. Whilst we've sort of still got you covering immigration before we move on to whistleblowing, actually a couple of really good questions came in over the last day or so. So we'll put you on the spot now. What about right to work requirements for EU nationals? So I guess that's always a sort of topic that we all need to focus on, but right to work requirements for EU nationals, do we need to check that they've applied under the EU settlement scheme?
Good question, Ed, because I think there has been lots of confusion around this, given that we've had Brexit, but obviously we're in this current transition period. The good news for employers is that you can continue to receive and check EU passports or EU ID cards as evidence of right to work during the current transition period. You want to encourage employees to apply, but you shouldn't be insisting on seeing evidence of their EU settlement scheme applications, because that is not yet mandatory. The rules on right to work will not change until January next year, so you do need to be mindful of being compliant with the current rules.
Fantastic. One more question for you. So this time around, sponsor licenses. So the question is, we already have a license for non-EU staff, but is there anything we need to do? For example, do we need to apply to have our license changed to allow us to employ EU employees?
Yeah, another good question there. So employers who already have a license in place, they're already in a good place ahead of the new system. But there are still a couple of things that it's worth trying to think about and focusing on. The first thing is you should review your compliance records. As I've mentioned, compliance is important, and you need to make sure your systems are sufficiently robust ahead of the new system so that you can carry on sponsorship without interruption and you don't run into issues with the UK authorities. The other thing you want to do is just check that your license actually covers all the categories that you need. The system is it's split into two main categories. So the tier 2 general, which covers new hires, and then there's a tier 2 intra-company transfer, which covers overseas secondees that you are moving across from your offices, say in Europe or outside the UK and the US. You need to make sure your license covers all those circumstances you might need to sponsor people on. And if you need to expand your license, you would need to apply and make a new application for this.
Very clear. Thank you very much, Moji. So moving on to our next question and our next slide, please. Whistleblowing or speak up, and how can you ensure best practice and encourage a speak up culture? Well, as I said, this is going to become critical in the current climate and going forwards. We've already started to see whistleblowing claims being brought in the employment tribunal for workers who've been dismissed for raising issues around PPE or who've been subjected to other detriments for raising other safety concerns in businesses that have continued operating. So how can you encourage those concerns to be raised in a more positive way and avoid ending up with a tribunal claim? Well, there are two key things here. Number one, first is your whistleblowing policy. It's perhaps worth dusting that off and looking at the language. Is it written in a way that encourages people to raise concerns? Does it set out the benefits of speaking up, perhaps even an obligation on all of us to speak up in certain situations? And does it provide clear assurances to staff that they will be protected if they do speak up? And on the subject of the policy, as I touched on earlier, I'm much more of a fan of calling this a speak up policy rather than whistleblowing, because speak up really encapsulates what you're trying to do, what you want your employees to do. You want to encourage them to speak up, to raise their concerns. And we've been working with lots of our clients, not just in the recent period, but over the last year or two, to review their policies to make sure that they're up to date with best practice and also facilitate speaking up as best they can. And that would be policies that include multiple internal and external channels for raising issues, and also with more of a focus on what organisations should do when they receive a speak up complaint. How should the complaint be triaged? What type of investigation, if any, should be carried out? Who makes that determination? All really important questions that can be overlooked. And secondly, and arguably the more important aspect of this, is training. It's important that all staff have training, including the board, so that the learning goes from the top down. But the most important level, we think, in terms of detailed training and having the right support, is line managers. They're most likely to receive whistleblowing complaints on a day-to-day basis, and they need to know how to recognise a complaint and how to respond, what to do next, and to avoid knee-jerk reactions. And we've been running speak up sessions for all levels of our clients' organisations, including boards, line managers, and staff. It's also worth having a good think about how speak up processes are going to work in the current climate. There are a number of issues which arise when conducting video interviews and investigations more generally on a remote basis. All of these we think can be dealt with, but they need to be thought about carefully and in advance. The legal issues are not new, they've always been there, but remote working has brought them more sharply into focus and created some additional legal and practical headaches. Essentially, the legal issues boil down to treating employees reasonably from a procedural perspective to avoid, for example, unfair dismissal claims, the general employer's duty of care, including regarding their mental health, more on that from Adam coming up, protecting those who blow the whistle or speak up, and then data protection and privacy issues as well. Now, ACAS has produced guidance on conducting investigations and hearings remotely, which sets out a few pointers to consider, can be found on the ACAS website. Practical things to think about in particular include flexing your processes and communicating clearly with those involved as to specific steps of the process you're following. The most obvious point, of course, being that you're moving away from in-person meetings to Zoom or other video conference meetings. In terms of evidence, how will you collect the relevant evidence if people are not in the office? Will somebody need to go in? If so, who should it be, and do any confidentiality issues arise? Are there any limits on the evidence you can collect? For example, hard copy files and handwritten notes are often relevant and may be hard to get hold of. And so does this mean that the investigation needs to go on hold? Then how will you send the relevant evidence and documents to those involved in the investigation? How will you make sure it's kept secure and confidential, given the employees that will be accessing it from home? And how can it be deleted or access restricted when you no longer need it? And then how will you carry out video interviews themselves? Will they be recorded or not? Do you need consent under GDPR? And how can you make sure they are secure and can't be accessed by anyone else who is not involved? As a related point, how will you communicate throughout this process? Are the communications sufficiently clear and regular? And is the method sufficiently secure? Does it need to be separate from the ordinary email system, for example? There are data protection issues to consider, as sensitive information may be being shared over platforms such as Zoom. And then, are there any employees who would need to be involved who are on furlough? If so, do you need to bring them back from furlough at any stage to be involved? Now, that question is very, very fact specific and would need to sort of have its own specific advice. But usually, you probably could be a witness in an investigation whilst on furlough. And although ACAS suggests you would be able to run an investigation while on furlough, we think that that runs the risk of being considered work. So you really need to be careful. Conversely, on the plus side, one thing which does become easier with a remote investigation is avoiding what can be a very awkward working relationship between the employee who raised a complaint and the accused, because they don't have to be in the office together. It also reduces the risk of victimization or retaliation, although the claimant's perception may be that they're being ignored or somehow treated differently. So complainants are perhaps more concerned than ever that they're being retaliated against, even though the risk is perhaps reduced in the current climate. Of course, another important factor here is mental health. You will all be very well aware of the impact that lockdown may have on your employees' mental health, particularly employees who live alone and may feel even more isolated. Indeed, a new ACAS commissioned YouGov survey has found that nearly 2 out of 5 employees working from home during the pandemic have felt stressed, anxious, or experienced mental health difficulties due to their working situation. And these sorts of concerns are even greater where an employee has blown the whistle or is being investigated following a speak up complaint or a grievance. This is difficult enough for the whistleblower or the accused when they're in the office, but being away from everyone could lead them to feel increasingly isolated and even paranoid. So it's especially important to ensure that they are kept informed of what stage the process is at and when they can expect to hear the conclusion, and that they are offered support or reminded of existing support, for example, employee counselling programs. Um, that brings us nicely on to our next topic, which is mental health more generally. But before I hand over to Adam, we've had a couple of queries on the whistleblowing section, and there was one question actually that I just wanted to quickly pick up because it's a particularly good one. So the question is if someone is accused of misconduct, do we need to suspend them if they're already working from home? Well, this is slightly less obvious if someone is already working from home. There may in fact be less need to suspend them. It's usually done where it's too difficult for individuals to work together during the investigation and or where evidence may be destroyed. And this, of course, may be less of a concern when people are not in the office. However, there may be other reasons, such as concerns about interfering with witnesses or wanting to prevent someone having access to your IT systems and confidential information. So, unfortunately, it's one that you need to assess on a case-by-case basis, but probably in most cases a bit less of a need for suspension. Okay, so we'll hand over to Adam now, who's going to take a look at managing mental health.
Thanks, Ed, and good afternoon, everybody. So moving on to our third question this afternoon, which is all about mental health and well-being, and what should employers be thinking about in this area? Well, it's a hugely big challenge for employers at the moment, and there are lots of different angles to this. So you might have employees who are on furlough who are worried about job security, or indeed you might be going through a restructuring or a redundancy consultation exercise. Also, as employees start to come back to work, there'll be people who are anxious about returning to the workplace, both for their own safety or the safety of loved ones at home. And of course, parents are facing huge challenges at the moment, trying to juggle work commitments with childcare and possibly also homeschooling. And as Ed mentioned, you'll have employees who are worried about the ongoing prospect of working from home, and those feelings of isolation and loneliness might be exacerbated by all of that. Well, what can you do to tackle all of this? Well, the first point really is around communication. I think communication is going to be critical in managing mental health in the workplace. It's more important now than ever for employers to be checking in with their staff regularly to see how they're doing. And rather than waiting for issues to arise, managers really need to be proactively speaking to their staff. So structuring regular check-ins to see how people are doing, both on a professional level and on a personal level. And Mind, the mental health charity, has come up with a really helpful tool to help employers do this. It's called a wellness action plan, and it's a bit like an appraisal. So there are a list of set questions which employees are encouraged to complete around things like what contributes to good mental health in the workplace, what might hinder your mental health, or what particular stressors or triggers for stress might there be for you, and what additional support do you need. And then the idea is that that's backed up with a conversation with the line manager around these issues and what sort of support can be put in place. And so there's an action plan which is developed from that. So as I said, very similar to an appraisal process, and it could be incorporated into an appraisal, or it could be dealt with completely separately. Well, of course, if managers are going to have these conversations, then they themselves are going to need some additional support. So training for managers on mental health awareness is going to be particularly critical. And I guess that training needs to cover, at a bare minimum, two things. So firstly, how to spot mental health issues in the workplace, because it can be really tricky to spot mental health concerns. It can be really subtle changes in behavior, like more mistakes being made, someone just appearing tired, someone being maybe slightly more withdrawn. Or it could be the other end of the spectrum where someone's sending loads of emails at 2 a.m. That might be another sort of warning sign that managers need to pick up on. So some sort of guidance on how to do that and how to spot those issues will be helpful. Then the second point that really needs to be covered in training is more on softer skills. So how do you go about having these conversations with your staff, which, let's face it, are slightly more awkward and uncomfortable for most people, and in some cases quite personal when you're asking how someone's doing. So any support you can give your managers to have those conversations will be really useful as well. And just knowing where you can go as an employee or as a manager within the organization to get additional support is also going to be important. So lots of organizations now have mental health first aiders or mental health champions who themselves have additional training in these areas. And that's really, really important, particularly if people are concerned that they can't go to their manager. They need to know who else they can go to if they've got any particular issues. Well, one of the huge challenges with mental health in the workplace that we come across quite a bit is the fact that somebody who's suffering from mental health issues doesn't always know that there's a problem, or isn't always prepared to admit that there's a problem. And that can be really, really difficult if you're trying to manage them. But I think having these sorts of structured one-to-one catch-ups will help identify issues before they turn into much bigger problems. And just a few quick points before I finish up on mental health. So while you're having individual discussions with your staff about their wellness and their well-being, there also needs to be a system of sort of overarching review and feedback, so that if there are any sort of thematic issues across the organization, these can be picked up at a macro level. And of course, confidentiality is really important here. So something like a confidential online survey might help in that regard. And as a separate point, managing holiday is going to be important. So encouraging staff to take their holiday is really important at the moment. I think we're all guilty of having cancelled pre-booked holiday because we can't travel or we can't go and see friends or family. But it's probably just as important, if not more important now, for us to carve out that time to rest and relax. And so for employers, I think the key will be to proactively encourage staff to take holiday more than you perhaps otherwise would. And finally, just to touch on the business case around mental health and well-being, clearly any measures that you implement are only going to be effective if you've got leadership buy-in. So in terms of how you do that, I think you can point to the impact of poor mental health on the bottom line. There are lots of statistics out there around sort of the impact of poor mental health in the workplace. It's estimated that absence and low productivity due to poor mental health costs businesses across the UK around £40 billion a year. And there are various other statistics that you can point to, and ACAS has a good list of those on its website. And of course, the other aspect of this is the legal angle. So if someone is showing signs of suffering and you fail to pick up on that and you fail to take action as an employer, well, you can be on the hook if things deteriorate. So if they have a breakdown or their mental health deteriorates into some sort of psychiatric condition. Now, those claims can be quite costly. Fortunately, they're very rare and they're usually covered by insurance, but it's something that you would want to avoid as an employer if at all possible.
Thanks very much for that, Adam. Conscious that time is ticking away quickly, lots to cover. So I'm just going to feed you one good question. Actually, you touched on this. And the question is, how often should we have mental health catch-ups? Should this be done annually as part of the appraisal process, or should it be more regular?
Yeah, that's a good question, and there's no sort of right answer to this. I think my preference would be to have a separate process for having mental health catch-ups. If it's part of the appraisal, there's a tendency, I guess, for it to be subsumed by discussions around career progression and work and other things like that. Good to have a structured catch-up at least annually, perhaps biannually, but I think it needs to be more regular than that. And particularly in the current climate, I think you want to be checking in with people every few weeks if you can, at least on an informal basis. So the more regularly you can do it, the better.
I completely endorse that. Agreed. So thank you for that, Adam. So we're now going to move on to our last couple of topics. So first up, the April changes to employment contracts, and then after that, the delay to the off-payroll rules. And Adam, I think you're going to cover both of those.
Yeah, thanks, Ed. So starting with the April changes to employment contracts, just a quick reminder of what this is all about. So there were some changes in April around the details that you need to include in your employment contract, and also the workers that you need to give these details to. So under the old rules, the pre-April rules, all employers had to provide all of their employees with what's called a statement of particulars of employment, and that had to be provided within 2 months of the employee starting work. Now that's usually often included in the offer letter or the employment contract itself rather than a separate document. But in terms of what's changed, as of the 6th of April, employers now need to give a statement of particulars to all of their workers, not just employees. So this will capture people like casual workers, the 0 hours workers, and it will also include people like LLP members who are technically workers as well, and so should get a statement of particulars. The second change is around timing. So the statement now needs to be provided by the first day of employment or the first day of engagement rather than within 2 months. So it needs to be provided up front. But the key change really is around what needs to go into the statement. So there are some new details that need to be included. So the statement now needs to include details of any benefits that you provide as an employer. And so a bit of thought needs to go into how you include these details in the employment contract, because obviously benefits might vary from grade to grade, and they might change over time. So lots of employers are thinking about putting schedules into the employment contract, or indeed trying to refer to a separate document, a benefits policy, which strictly may not comply with the new rules, but is a practical solution. And similarly, the statement now has to include details of any other paid leave that the employer offers. So in addition to things like holiday and sick leave, this would include things like family-friendly leave. But the good news with this is that you can refer to a separate policy. So the easiest thing to do is to simply refer to the handbook or your family-friendly policies for more information there. And finally, you've got to include details of any training entitlement or any training requirement that employees are required to undergo. So if there's any specific training that employees have to complete as part of their job, then you need to include this in the employment contract as well. Now, most of our clients have already updated their contracts to reflect these changes. But if you haven't done so already, then now is the perfect opportunity to do that. While there's a bit of a hiatus on recruitment at the moment, it's worth spending the time to get your ducks in a row and updating your contracts so you're ready for when the economy improves and you may need to be recruiting people rather quickly.
Thanks very much, Adam. And I think it's fair to say that lots of our clients probably haven't updated their contracts. So don't feel that you should be on the naughty step if you haven't done that yet. And we can certainly support with what's generally a pretty straightforward task, updating your pro formas. Okay, so whizzing on to our final topic now, and this is the off-payroll working rules. So on to the next slide if we can. You'll remember that back in March, the government announced that the changes to the off-payroll rules in the private sector would be delayed from April this year until the 6th of April 2021 to essentially ease the pressure on businesses in the light of coronavirus. And there's been some speculation about whether the changes really will come in from April next year. Adam, what do you think about that? I mean, is there a chance of this being kicked further down the road or perhaps scrapped altogether?
Yeah, it's a really good question, Ed, and I guess it's impossible to say at the moment, but the rules have certainly come under a lot of criticism, particularly from the House of Lords, who've actually argued that they should be scrapped altogether. Or at the very least delayed further than April next year, because businesses are still going to be recovering from the economic shock of the coronavirus pandemic in April next year. So there's a big argument for the rules to be delayed. But from what we've seen so far, the government seems pretty adamant that the rules are going to come in April 2021. So just last week, there was some new legislation tabled, which talks about the implementation date of the 6th of April 2021. And of course, the government's going to have a huge debt to try and recover. And the off-payroll rules have always been a real source of revenue for the government. So I can see that they'd be very keen to bring them in as soon as possible. So just a quick reminder what the off-payroll rules are all about. So these are the rules that govern how you tax and engage contractors who supply their services through a limited company or a personal services company. They already apply in the public sector, and the plan is to introduce them into the private sector from the 6th of April next year. They'll apply to large and medium-sized businesses in the private sector, so there'll be a carve out for small businesses. And what they essentially mean is that whenever you engage someone via a personal services company, you have to decide whether, if you took away that personal services company, they would be an employee for tax purposes. So this is the IR35 test that lots of you will be very familiar with. And if you decide that someone is within IR35, then you've got to treat them as an employee for tax purposes. So you've got to deduct tax and national insurance, and that includes employee and employer national insurance and other things like the apprenticeship levy, and account for those. And if you're not responsible for paying the contractor, so you've got an agency who pays the contractor, then it's the agency who's got to deduct the tax and national insurance. But you, as the end client, always have the responsibility to make the determination, are they inside or outside IR35? So what does the delay to the rules mean, and what should you be doing now to prepare? Well, I guess unfortunately, as a starting point, the exercise that you probably went through earlier this year or at the back end of last year of auditing your contractor workforce to work out who you've got and what sort of arrangements you've got with them is going to need to be repeated. So you're going to need to look again at your contractor workforce and decide which contractors you've got, what sorts of arrangements they're on. So that sort of audit will need to happen again at some time towards the end of this year, or at the very latest early next year. And the second point is you're going to need to prepare fresh statements of status determination statements for those contractors. So this is the statement that says whether they're inside or outside IR35. And that's the case whether you've already done the status determination for the contractor or not. That's going to need to be refreshed and a new statement issued because things might have changed in the last 12 months. And don't forget, under the off-payroll rules, the contractor and the agency both have a right to challenge your status determination statement. So they can say, no, we disagree with your analysis, and you've got to listen to any representations that they make and then give a decision within 45 days, either confirming your original decision or issuing a fresh status determination statement. And finally, of course, you need to think about any contractors that you engage between now and April next year. If it's likely that they're going to continue providing services beyond the 6th of April, then you'll want to build in some wording into the contract that says you can deduct tax and national insurance from the 6th of April if you decide they're inside IR35, or at the very least you can renegotiate the pay arrangements early next year in preparation for the off-payroll rules. One further change which has come in, we were expecting this, but it's come into the draft legislation that was tabled last week, is a new right for the contractor or the agency to ask you as an organisation whether you satisfy the small company definition. So as I said, if you are a small company, then you're outside the IR35 rules, the off-payroll rules won't apply to you. And so the contractor can ask you to provide details of your size, and you've got to respond within 45 days of that request. But otherwise, the draft legislation is largely, as we expected, a mirror image of the rules as they were expected to come in April this year, just with the revised start date of the 6th of April 2021.
Thanks very much, Adam. Excellent question came in actually, which is pertinent to the final substantive point you made. So how do you decide if you're a small company to work out if the rules apply to you?
Yeah, okay, so this tracks the small company definition in the Companies Act. So you've got 3 criteria. It's based on the number of employees, your turnover, and your balance sheet. So if you satisfy 2 out of those 3 criteria, you'll be a small business or a small company. And they are, you've got no more than 50 employees, you've got turnover of no more than £10.2 million, and a balance sheet total of no more than 5.1 million. So if you hit 2 out of 3 of those, then you're a small company outside the scope of the off-payroll rules. But the slight catch there is you need to look at this on a group-wide basis. So if you're a parent and as a group you've aggregated the number of employees, turnover, balance sheet, and that takes you outside of this test, then you'll still be within the rules. So you need to look at it on a group-wide basis, unfortunately, rather than entity by entity.
Fantastic. Well, look, time has ticked on apace. I think we've covered a lot of ground there. So, well, in terms of questions, obviously we picked up a good number of the ones that people have posted in advance of the session. I'm sure a number of good questions have come in during the session, and we will get back to you in respect of those. But that just leaves me to say thanks very much for joining today's webinar and listening in, not just today actually, but to the previous sessions in this series that we've been running throughout May. We've had a great take up for these sessions, and we'll certainly be looking to run further webinars later on during 2020. We hope to see some of you in person before the back end of the year. And clearly a hot topic going forward is going to be immigration, but there's lots going on in the employment world more generally. So do stay tuned in for future events. And as always, do let us know if you've any feedback or suggestions for future sessions. We're keen to hear, and we'll often frame things around the suggestions that you make. And of course, do pick up with us if there's anything from today or any of the other sessions that you'd like to discuss. So thanks all for listening in, and goodbye for now.